In early medieval times, English law concerning innkeepers was just beginning to develop. Innkeepers were considered servants of the public in the fact that they had a duty of care to their guests. In the case of Beaubec versus Waltham, William Beaubec sued the innkeeper, John of Waltham, for the loss of personal property. The case was important because it helped to outline the duty of care that innkeepers owe to their guests. This case influenced future laws, creating precedents that innkeepers would be held liable for the loss of guest items when taken into their care. Strict liability came into play in English law in the late 14th century when criminal activity at inns, a place where guests expected a certain level of care, placed the liability on dishonest innkeepers. The Plague, or Black Death, allowed the Crown to create new laws and rules to assign liability to those who were negligent in criminal activities. According to Robert Palmer, the liability to innkeepers for the belongings of their guests began in 1365. Because of the decrease in population from the plague, the standard of care at the inns dropped considerably, leading to government intervention. Infrahospitium is the term for when a guest and their belongings arrive at the inn. The innkeeper's duty of care begins, meaning that the innkeeper is now responsible for loss or theft of the guest's belongings, so long as the loss or theft is not due to an act of God, a public enemy, or from the guest's own negligence. The origin of negligence for guest property began in the Middle Ages, when more travelers traveled by foot. Since there were many robbers and outlaws on these roads, the travelers tended to travel light with minimal belongings. They would get their food and rest at inns along the road. Since the innkeepers were unknown to these travelers, they took a risk with the items that they did travel with. To protect the travelers, liability was placed on the innkeeper for the full amount of the guest's belongings. English settlers that traveled to America took these common laws with them. In 1890, Washington made a statute that if an innkeeper provided a safe for travelers, the innkeeper would not be held liable if the guests put their valuable goods, such as money, jewelry, and precious stones, inside the safe. In 1915, a statute was created that allowed for limited liability to be extended to the innkeepers. The safe was to be made available for the guests, but the innkeeper was not required to take any item that was worth more than $1,000. That limited the liability to the innkeeper, so that the amount, unless there was a contract made with the guest for other arrangements. In 1933, several changes were made to that statute to say that the innkeeper would not be fully responsible for the loss of the guest's belongings anymore unless the gross negligence of the innkeeper or staff was the cause of the belongings being lost. Should the belongings be lost due to an act of God, a public enemy, or the guests themselves, the hotel would not be considered liable. The innkeeper's lien was created to give the opportunity to the innkeepers to keep the guest's belongings, should the guest not pay their bill or cause damage to the hotel in some way. The innkeepers could keep and sell the guest's property to repay any unpaid bills the guest may have neglected to pay. The lien allows for the innkeeper to forego a court hearing for reimbursement of charges and take the guest's belongings as collateral. Should the guest pay their outstanding bill, their belongings will be returned to them. Hotel liability for guest property today has not had any major changes in recent times. Most businesses operating as lodging are subject to federal and state laws. These businesses are not allowed to discriminate and must accept any reasonable person who intends to be a guest. The hotel is responsible for the guest's safety and their belongings. However, there is limited liability to the guest's belongings. If a safe is available for the guest at the reception desk and proper signage is posted within the hotel, then the hotel, unless grossly negligent, is subject to limited liability. Safes within the guest's rooms are usually not covered under limited liability if a main hotel safe is available. Most liability is up to items $1,000, and hotels are not required to take anything of higher value. Once the guest pays their bill and checks out of the hotel, the relationship between the guest and the hotel has ended. However, until the guest's belongings are either taken with the guest or their belongings are delivered to another destination, the hotel is still liable in the sense that they are now a gratuitous bailee and do not owe the same duty of care. Once the guest and their belongings are gone, the hotel is no longer responsible for any duty of care.